The Sunday Post newspaper asked me to comment on an article that they were running about a person who had been overcharged in relation to a parking offence. The so-called parking offence was parking on some wasteland where a sign had been placed saying that parking carried a certain charge. And they wanted to know if there is a legitimate method for these companies to chase you for that debt, and if you've really established that debt. And the first issue that I would suggest you always have to look at in these cases is, can this company prove that you are the driver of the vehicle and that you parked the vehicle there in the first place? Now, that's a big hurdle for them to get round, and how they try to get round it is they send you a notice that looks awful like a section 172 notice, or a notice of intended prosecution, and it looks like it's from the police, or it looks like it might have the authority of the police, and it demands to know from you if you were driving or if you parked the vehicle on that particular date and time. My advice is that you don't respond to that correspondence. At the end of the day, parking on a piece of wasteland or where there is a civil claim means that the case would have to come to court, and this company will require to prove that you are the person who owes the company the debt. Now, I'm not one to say that people should run away from legitimate debts. That's not what this video is about, or this blog post is about. And if you're aware that you are parking there under an agreement and you did so and you breached that agreement, then you may well be liable for the penalty that's been incurred. What I would say, however, is that I'm concerned that the type of letters that are then sent out from these companies tend to be really heavy-handed, and all of a sudden you end up with £200 or £300 worth of debt and legal costs. And it's very worrying and upsetting and frightening, particularly for elderly drivers who have parked their vehicle. The next minute, within a couple of weeks, they're being faced with £200 or £300 as a bill. Now, the essence of what I'm saying today is that this is a civil debt, which means the company would ultimately require to sue you and bring the case before a sheriff. They therefore require to prove that you're the person that drove the vehicle. So my advice is simple and straightforward. Don't enter into any discussions, don't enter into any correspondence with that company. It's for them to establish at a later stage, if they choose to raise a case against you, that you're the person that parked your vehicle there. Bear in mind that the test that they have to set is on the balance of probabilities. And that basically means that they're going to have to establish to the court that if you're the registered keeper of that vehicle, that you were the person who parked on that particular day. And there's quite a lot to do to establish that. In relation to minor road traffic cases like speeding and the like, you are required to answer the notice of intended prosecution that you receive from the Road Safety Camera Partnership or from the police. That's a legal requirement. Don't mix it up with this situation. Now, this blog is not about giving you advice in relation to a civil case. This blog is just about telling you, be aware of it, look out for it, and if you need advice with it, go to a solicitor who can assist with that type of thing. We don't actually deal with that type of issue, but we're asked about it almost on a weekly basis. So that was the whole purpose of this blog post. If you are in receipt of documentation from such a company, I think just to be assured that you're in a good position, it would make sense to speak to your local solicitor or speak to a legal advisor who can give you some particular advice about your own case and your own circumstances. But my own view in general would be not to respond to correspondence from this type of company, not to be worried by the outrageous claims that some of them are making, and to seek legal advice as soon as you can.